Hi, everyone. My name is Rachel Marks, and I'm the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible William Porter, a California construction lien law guru. Today's webinar's topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the fabulous William Porter.
Well, thanks so much, Rachel. That was an introduction that was much more than I deserve. You exaggerated, but I'm happy to help everyone out today. We're going to go on for about 20 minutes on these subjects. And so much more can be said on them, but I don't want you to get too bored. And you can always, if you want to, you could give me a call and say you were at the webinar and you had a question, okay? And of course, this is all dealing with California law, and we're going to talk about getting paid faster with liens, bonds, and contracts. So without further ado, let's move into it a little bit here, okay? If you have any questions, then use the chat box on the right, I think is on your screens. And then at the end, we'll take the questions, okay? I'll prompt Rachel and we'll see if we have any questions. Okay, and of course, as I mentioned, you can always give me a call and say you're at the webinar and you have a question. Okay, this is just a little legal disclaimer. You know, we can't be exact on everything. There's always exceptions to everything, but I'm going to be hitting general rules, so we should, I think, be okay on that. Here's some stuff about myself, but there's no need to bore you with that. Go right past it. Okay, so let's talk about contracts now. Let me say a few things about that. When you receive a contract, there's two ways that you get contracts. Either it's your own, in which case you should draft it very carefully to be favorable towards your position in every way possible. And then when you're presenting that to another person, sometimes they just sign it, and all your reasonable and beneficial provisions towards yourself become part of the contract, which is great. But a lot of times you have someone else's contract. So it's important that you go over it. You want to offer edits. One of the most important edits that you can offer on getting paid quicker is those provisions you see in a contract that often say, let's say you're a subcontractor, and the prime contract that you sign that you get from the contractor says that we will not pay you until we work out our differences with the owner, and you will wait all this time for that. Now, there's been some cases that have come down recently. On one of them that it's mentioned on this page, this Krosno case, okay, and that had to do with a public works payment bond. It essentially said that it's unreasonable to require someone to wait forever, which could be years, while the owner and the prime contractor work out their difficulties and differences and go through all the mediation, arbitration, possibly court before you get paid. So what I would say is when you're going to edit something having to do with when you get paid, you want to put a time limit in there. They will go through a lot of language talking about the procedure for you to get paid and how you have to wait. And then you want to put in something in there like not to exceed some number of months. And the Krosno case was, basically they ended up with 6 months. So I take those provisions and I edit them so they say no later than 6 months. Also, I put in a provision in there sometimes that passes that says no later than the day on which a contractor by law is required to meet the deadline to enforce claims. And so including mechanics lien, stop notice, and payment bond claims. Now that seems very reasonable, but that makes it even shorter than 6 months. Anyway, you want to get in there and limit that amount of time that you have to wait. Also, in some cases, I've mentioned here, there's a case, Clark versus Safeco, and you will encounter a lot of times in your contracts that something that says we don't have to pay you until we get paid at all, or if we don't get paid, we don't have to pay you. Now that has been declared to be illegal by Clark versus Safeco. So the GC getting paid can't be a condition precedent or precedent either way to you getting paid. So the Supreme Court of the State of California says, no, we're not going to allow those provisions. So a lot of times you'll encounter those, and I just write in the margin, illegal, Clark versus Safeco. That's what I write. Okay, and then I mentioned the Krosno case. It basically said you can't have an indefinite pay deadline. Now that was public works, but I try to argue it for private works as well. We will see how the law develops, but these are the kind of things that you want to argue so that you don't have to wait forever to get paid. Okay, also on your contracts, you're going to want to have an attorney fee clause in there. A lot of the larger contracts, they'll put attorney fee clauses in there because they know they're going to have, like, let's say 20 subcontractors, and they're not going to want to lose their case and pay all those subcontractors all their attorney fees. So they don't put in an attorney fee clause because oftentimes they're really in the wrong. And it's unfortunate, but this is the reality. I've been doing this over 30 years, and I see the reality. I know that GCs often know they're wrong, but they have leverage over their subcontractors. Okay, so you want to have an attorney fee clause in there if you can, and it will basically say, and it can't be in the indemnity clause. The indemnity clause attorney fee is considered different. So you have to have an attorney fee clause other than inside the indemnity clause in your contract. In any event, you'll say something like, if a dispute arises between the contractor and the subcontractor, the prevailing party shall be entitled to their reasonable attorney fees and costs. And you might even add in there and expert fees and costs of arbitration. These are things that you can add in. Now, doing that kind of gives you an advantage, which I'll discuss in just a moment. Let me add here, because it's listed, arbitration, yes, go for that, but don't probably have a mediation clause. I mean, you can always voluntarily agree to mediate, but a lot of times what happens in mediation is that you lay out your entire case, and the other side says, oh, basically, thank you for laying out your entire case so we know all about it, but mediation is a voluntary process, and we choose not to reach resolution, but we sure did appreciate you showing us all the good stuff you have in your case. So you gotta approach mediation with caution. If you have a very good mediator with a good track record, it might be okay. All right. I prefer arbitration, which is basically the same as going to court and having a decision made, except you're before an arbitrator. It's in an informal process. You're in the arbitrator's office, and then they make the decision. Okay. Now, also, you want in your contract interest. You can go pretty much in California as high as 1.5% interest per month on late payments. That's about the most. Also, though, we have, which I'll talk about, we have prompt payment remedies in this case, in this state, which can go like 2% a month. So if sometimes you have to choose between the interest rate in your contract, let's say it's 1.5, and the 2% per month, which is maybe when an owner doesn't pay you when they should, or when a contractor doesn't pay you when they were paid for your work and didn't pass it on, then the penalty is 2% a month. Under some statutes, you can get the 2% a month plus the 1.5% per month that's in your contract. That's 3.5% a month. What is that? That's like 42% a year. Boy, that's a really good rate of return. Okay. Now, the reason I mention these things is because when you're arguing to get paid, if you have these things, if you have an arbitration clause, you could say to the other side, okay, hey, look, and you have the attorney fee clause and you have the interest clause, you can say, okay, fine, particularly when you know you're in the right. Let's go to court, or let's go to arbitration, because you know what, Mr. Contractor who hasn't paid me, you're going to pay not only the money that you owe me, you're going to pay me interest at 1.5% a month. And if prompt payment interest applies, then you're going to pay me additional 2% a month. That's 3.5% a month. Fine. You want to go, you stretch this out a year or two? Okay, that's that 42% a year. That's fine. Oh yeah, and then not only when you lose are you going to pay your own attorney for the year and a half of work you did on this case, but you're going to pay my attorney too, because I'm going to be the prevailing party, and you're going to end up paying both sides of fees, all the money you owe me, all this interest, and all that. Why don't we? And then the argument is, why don't we just avoid all that? Okay, but to do this, you have to have the proper tools in your contract. As far as indemnity goes, that's an important clause. You want to avoid the obligation to defend. Okay, it's noted there. Also, you want to avoid the word solely. And if you look at your indemnity clauses, it'll say, you defend and indemnify us unless it's solely our fault, which means that they're not even responsible for 1% of fault, which is hardly ever. So you want to avoid that word. It'll be beneficial. Comparative fault is okay. It's fair. It means that if you're 30% at fault, then you're going to pay 30% of the attorney fees and costs and all that. And whoever is responsible for the other 70% will pay their 70% worth. So that's all fair. Okay, let's move on from that. In the contracts, you're going to want to follow the claims procedure in the contract to the letter. Okay, find that claims procedure process and don't mess it up, because then they will have a defense that you didn't follow the process. Okay, when you're editing a contract, what you have to do is you're going to have to make all your changes to the contract. Let's say you do it by hand. You could also do it by computer system if the document allows you to do that. But in any event, the other side has to initial all the changes, as do you, before you sign. You always have to get the other side, don't forget, to initial all the changes before everybody signs, because the only changes that are going to be enforceable are the ones that are initialed by both sides, and then everyone has signed. Okay, and then finally, during the project, always communicate in writing. You can use emails, that's all fine. I would avoid communicating by text because it has its own problems. And then one of the things I like to say is, when you have a dispute and the other side tends to not respond, then you say, okay, you have a conversation with them, and then you respond back to them by email and say, thank you for the conversation today. To confirm what we discussed, it is as follows. And then you describe it favorably towards your position. And then you say, if you have any dispute with what I said, please respond to me as soon as possible or immediately in writing. And if you don't, then I will understand that you don't disagree with what I have stated above. Now, if you have that as evidence and they don't respond, when you go to arbitration or court at a later time, the judge is going to say to the other side, well, they gave you an opportunity to disagree with them, and you passed on it. So you know what? I'm going to take what they say as an accurate picture of what happened. So that'll be to your benefit. Okay, that's the discussion I wanted to have on contracts. Now, if you want to have strong rights to get paid, and you want to really have leverage over the other side, the answer to that is you have to have your mechanics lien right, your stop payment notice right, and your payment bond claim rights in place. Okay, that all starts with the preliminary notice. In private works, all subs and suppliers have to send out a preliminary notice. And SunRay can help you with that, I am sure. All right. You can also do it yourself. Okay. And as far as private works, when there's a construction loan, then also the general contractors have to send out a preliminary notice. Otherwise, they won't have a right to those construction loan funds. Okay. So remember, in most cases, all substance suppliers and private works have to send out the preliminary notice. And where there's a construction loan in place, the GCs also have to send a preliminary notice. Now, in public works projects, the GC never has to send out anything, and the first tier subs don't have to send out anything. But everyone else, other than that, has to send out a preliminary notice, so they'll have a right to either a mechanics lien, stop payment notice, or a payment bond claim, or all three. Of course, with public works, you can't have a mechanics lien claim, because that results in selling of the property, and they don't want public property to get sold, so they kind of carved that out, which I guess was pretty smart on their end. Okay, also there's these releases. Okay, there's the conditional, unconditional, progress, and final. You want to use them properly. The civil code shows them, and it's 8132 to 8138, and you can look them up, but use them properly. When it is a conditional, it means that you're going to get a check, and if the check doesn't bounce, then basically you've released the claims. Be sure to fill them out properly. There's videos. I have some videos that you can access through our website on how to fill them out properly, and I'm sure SunRay can take care of it for you as well. Okay, then the next thing is the mechanics lien. This is wonderful leverage. Now, you want to watch the deadline for recording the mechanics lien in your lawsuit. So briefly, the mechanics lien allows you to sell the property where you work in order to take the proceeds of the sale and pay yourself. It's a huge leverage that you, let's say you're a subcontractor supplier, that you would have over the owner. Because remember, if you're a sub or supplier, you don't even have a contract with the owner. So you can't sue the owner for breach of contract, but if you have a mechanics lien right, you can sell the owner's property, and that's valuable. So to record a mechanics lien, it's going to be either 30 days or 60 days or 90 days to record the lien. If you're a sub and there's a notice of completion, you're only going to usually have 30 days to record the lien. If you're the prime contractor, you're going to have 60 days after a notice of completion to record the lien. If there's no notice of completion, then everybody is going to have 90 days after the project is completed to record the lien. Then after that, everyone is going to have 90 more days, if needed, to file a lawsuit on that lien, a lien foreclosure lawsuit, which will include other claims, but those are your deadlines, 30, 60, 90, and then another 90 for the lawsuit. That's the mechanics lien. There's all kinds of things on our website, porterlaw.com, about mechanics liens, okay? There's also info on there on stop payment notices. This is great leverage against the general contractor. You have to send a stop payment notice within 30 days of a notice of completion, or 90 days from project completion if there's no notice of completion, and then 90 more days for a lawsuit. It can be a little bit more than 90 days, but if you use 90 as your measurement, you'll never miss the deadline. So what this does, the stop payment notice, it stops money from flowing from the lender or the owner to the GC, and it holds it. It holds 125% of that amount. So that's leverage. So let's say you have the mechanics lien and the stop payment notice. It's huge leverage. A third type of claim is a payment bond claim, if there is a payment bond. Now, in private works, there's not often a payment bond, but on larger projects there is. You're going to want to find out if there is one. And on public works, there's always generally going to be a payment bond in California. So look, your leverage in getting paid quicker is you're going to have, you'll do your preliminary notice, then you'll have a mechanics lien claim, a stop payment notice claim, and a payment bond claim. You'll be covered in 3 different ways. Doesn't mean you get paid triple, but that'll all get worked out. But it gives you a lot of strength and a lot of leverage, and it helps you get paid. So arguments to resolve quickly using those tools, all the above we discussed, plus you want to be in the right. I mean, you can't make these arguments if you're in the wrong and you maybe messed up a job or you did poor work or something. But if you're in the right, then you want to argue all these things. You want to argue attorney fees because you'll win. You want to get interest. You want to get prompt payment interest, which is generally 2% a month. There's that 42% I mentioned in some cases. And then the argument is, you know, other side of the case, it's best to settle early and avoid unnecessary expenses. So let me see what I have here. That's where I am right now. And Rachel, I wondered if we have any questions.
Okay, well, first of all, I would just like to say thank you so much, Bill, for your time this afternoon and educating us on this very important topic. You provided us with super, super helpful and extremely valuable information. So thank you so much. Right now, I do not see any questions that have come through. Let's see here.
Okay, well, if somebody does have a question and they want to call my office, my number is there on the screen, as well as.
Absolutely. Yes, and if you guys do have a question that you think of after the fact, just feel free to reach out to myself or Bill, and we will make sure to answer any questions that you may have. If you'll just do me a favor, Bill, and just go to the next screen, I want to talk about our upcoming webinars with you. Okay, so if you'd like to take a moment to review us on Google, we would appreciate that. And then if you'll go to the next screen for me. Okay, so I wanted to talk about our next webinar with Bill. So that will be on Thursday, September 28th from 1 to 1:20. And the title of the next webinar is What Happens After I Record My Lien? How do I get paid? So go ahead and register at sunraynotice.com/education. And if you'll go to the next slide for me. That's all we have for you. So thank you everyone for joining us today. And thank you, Bill, for your time this afternoon. We really, really appreciate all the helpful information you have given us.
Well, thank you, Rachel, and thank you to everyone who joined us today. And again, if any of you have any questions, don't hesitate to give me a call. I hope I can help you out. Also at porterlaw.com, there's a lot of articles that you might find of interest on topics relating to California construction. Thanks so much, Rachel, and everyone.
Thank you. I hope everyone has a sunny day.